Okay, I think we'll get started here. Hi, everyone. Thanks for coming to the second panel. Our moderator for this panel will be Professor Mark McKenna. Professor McKenna teaches and writes in the area of intellectual property at the Notre Dame Law School. He graduated from the University of Notre Dame in 1997 with a degree in economics and earned his GD from the University of Virginia School of Law in 2000. After graduating from law school, Professor McKenna practiced law with an intellectual property firm in Chicago, litigating trademark and copyright cases and advising clients on a variety of intellectual property issues. So without further ado, I'll just hand the floor over to Professor McKenna.
So I had just told Fred that in the interest of time, I was not going to read his entire list of accomplishments. So I was kind of hoping for a shorter introduction myself, just so I wouldn't. So we have an interesting panel of papers. I'll just sort of introduce each of them quickly, and then they'll go and we'll do questions at the end. So first is going to be Christina Bohannon from the University of Iowa College of Law, where she's been for several years. Christina graduated from the University of Florida in 1994, and also got her JD from Florida in 1997, where she finished first in her class and then clerked on the 11th Circuit. So Christina teaches torts, copyrights, and conflicts, and is going to talk to us today about First Amendment issues in copyright. And then it's going to be Alina Ng, who teaches at the Mississippi College School of Law, where she's been since 2007, after having most recently gotten her JSD from Stanford. And she teaches cyberspace, intellectual property, and law economics. And then last will be Fred Yen, who's a professor of law at Boston College Law School and the Law School Fund Scholar and the director of Emerging Enterprises and Business Law program. So Fred's also a graduate of Stanford University and the Harvard Law School and joined Boston College in 1987. So.
Okay, so first I want to thank the Journal and Spencer especially and her team in organizing this. I really appreciate the invitation, and this has been very interesting. In fact, it was so interesting, that's why we were late. Professor Cotter and I were having a very animated discussion of the harm and fair use issues from the last panel. In this panel, a lot of this is focusing on First Amendment, and so what I want to talk about today that is relevant or related to the last panel is the problem of First Amendment overbreadth and vagueness in the derivative works right, and in particular at the intersection of the derivative works right and fair use. And in order to do that, in the paper I'll talk about the Supreme Court and other jurisprudence on overbreadth and vagueness generally, but in this talk I'm going to focus mainly on the recent dogfighting case, which kind of provides an interesting point of departure, because although that seems to be a very different type of statute than the Copyright Act, there actually are some pretty interesting similarities. So just to give you a little bit of background about that case. The Supreme Court has recently heard oral arguments in United States versus Stevens. For those of you who don't know, that case involves the sort of dogfighting video case. And there, we have the dogfighting video statute says that anyone who knowingly creates, sells, or possesses a depiction of animal cruelty with the intention of placing that depiction in interstate or foreign commerce for commercial gain it can be punished, and there's a potential jail time and a fine. It defines that the prohibited depiction, and I'll go through that later. It also has an exception for depictions with serious religious, political, scientific, educational, journalistic, historical, or artistic value. The Third Circuit, despite that exceptions clause, held that the statute violates the First Amendment. It held that these video depictions of animal cruelty, in this case mostly dogfighting, are protected speech. And second, that the statute was not narrowly tailored to address the underlying problem of animal cruelty. Because although there are some instances of animal cruelty depicted in these videos that are unlawful, it also prohibited depictions of animal cruelty that in many places are not unlawful, such as hunting or bullfighting, those kinds of things. Also, the Third Circuit suggested in dicta that the statute might be unconstitutionally overbroad. The court explained that under the overbreadth doctrine, it's required to examine the plain language of the statute to determine whether a substantial amount of protected speech is prohibited or chilled in the process of enforcing the statute, and the court concluded that the statute potentially covers a great deal of constitutionally protected speech beyond what it actually is trying to prosecute. So the Supreme Court granted cert, and recently the court heard oral arguments, and based on those oral arguments, it seems fairly likely that the Supreme Court will hold the statute unconstitutional, either on grounds that it's not narrowly tailored to serve its purpose or that it's unconstitutionally overbroad or vague. For instance, at oral argument, Justice Breyer said that the language of the exceptions clause, that is the exception for serious religious, political, educational value, so far and so on, is vague, and that people won't know what conduct falls within the exemption, and therefore that people won't know whether they can make this particular film, picture, or other. That's the overbreadth argument, according to Justice Breyer. Okay, so here, what I want to do is talk a little bit about how the derivative works right, and particularly the relationship between the derivative works right and the fair use doctrine is similar in some ways to this statute, in ways that suggest that there might be some overbreadth or vagueness that we ought to be concerned about. So first, both the animal cruelty video depiction of animal cruelty statute and the Copyright Act and the derivative works right do regulate speech. Okay, in the animal case, the dogfighting case, there the court said that depictions of animal cruelty are speech. Maybe the underlying conduct of having dogs fight and those sorts of things isn't speech, but that depictions of that can be. People use these kinds of videos for political purposes, to make political statements, for historical purposes, things like that. In copyright, the derivative works right does regulate speech. I think that's fairly obvious, but just for those concerned about, well, what does Eldred mean in this context and that sort of thing. In Eldred versus Ashcroft, the court did not apply heightened First Amendment scrutiny to the Copyright Term Extension Act. It said that it's just going to use ordinary rational basis review. And there were a couple of reasons why the court said that. The court said that copying is not the same thing as speaking. Okay, so that's one reason. And two, the court said that the Copyright Term Extension Act merely extended the duration of protection but did not expand the scope of protection, and in particular did not alter copyright's traditional contours, including the idea-expression dichotomy and the fair use doctrine. But the derivative works right is a little different from the Copyright Term Extension Act. In the derivative works right, we're talking by definition about situations in which people have not merely copied, but have actually changed the work in some way, adding new expression. And so it does seem like we're talking about more than mere copying here and are venturing over into speaking. There are good arguments that copying itself is speech, but in the derivative works right, we can agree that there's maybe even a stronger argument that it's speech because of this kind of transformation that goes on. Second, the derivative works right does alter the scope of copyright. Now, we've had some debate today about whether it really does that, and it's true that as of today, a lot of the things that would be captured in the derivative works right are also going to violate the right of reproduction. But that's not to say that historically the derivative works right has not had an effect on the scope of infringement. If you can think about, for example, there have been cases where courts struggled with this. The Uncle Tom's Cabin case, there the court held that a translation was not a reproduction. And then we come along with the derivative works right and say, oh, but it is, okay? And so basically what happens is that the derivative works right kind of has this expansive effect on what we think of as reproduction. For example, another example would be the Dr. Seuss case, with the rhyming, kind of like Dr. Seuss and the stovepipe hat. It's very possible that without a derivative works right, a court might look at that, although the Ninth Circuit didn't necessarily. But it's very possible, a court might look at that and say, well, this isn't enough of a reproduction to constitute infringement. But with the presence of the derivative works right there, suddenly the court's thinking, okay, is this a reproduction? Well, that you also have the right to prepare derivative works, which would seem to give us a more expansive definition of what constitutes an infringing use. So I think that it's more implicit and historical, but it does seem to have an effect on the scope. It also can affect the traditional contours, particularly fair use, because as we've seen already, the derivative works right gives the copyright holder the exclusive right to transform the use, but fair use tends to protect transformative uses and says that transformativeness tends to favor a finding of fair use. And so there is this tension there where the same word is essentially being used to mean two different things and to point in two different directions on a finding of infringement. And so the derivative works right does seem to affect the traditional contour of fair use. Okay, so it's possible here that we would have heightened scrutiny even under Eldred versus Ashcroft. Even if not, courts tend to apply overbreadth and vagueness kinds of considerations, even to across the board to all kinds of laws that regulate speech. So even if we don't find that the derivative works right is particularly subject to some heightened scrutiny, the overbreadth and vagueness concerns are usually still concerns for the court. Okay, so that's one similarity between the two. The baseline, they both regulate speech. Second, the prohibitions in both the dogfighting statute and in the derivative works right are very broad. In the dogfighting statute, the statute defines the prohibited depiction of animal cruelty as any visual or auditory depiction, including any photograph, motion picture, film, video recording, electronic image, or sound recording of conduct in which a living animal is intentionally maimed, mutilated, tortured, wounded, or killed. Sorry for the disgusting content here. But here the court was concerned that this is a very broad prohibition, that it would cover things like killing, even in the context of hunting, which is lawful in most states. The Copyright Act likewise prohibits preparing derivative works, and it defines derivative works in a way that almost sounds a little bit like some of the dogfighting prohibition. It says that it prohibits preparing a work based upon the copyrighted work, including a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. Okay, that is extremely broad language in a number of ways. Judge Kaczynski has talked about, has characterized this as hopelessly overbroad, saying that every new work has to build on old works. Also, the statute doesn't define a lot of its terms. And if you take a couple of the pieces together, it can lead to pretty broad results. For example, the statute says that the new work just has to be based upon an existing work. It doesn't actually say that you have to incorporate copyrighted expression from an old work into a new work. Well, combine that with a term like fictionalization, which is one of the categories of derivative work here. So when Dan Brown writes the Da Vinci Code, and he goes back to this nonfiction work, Holy Blood and Holy Grail, and it's based on that in part, and it's a fictionalization of some of that underlying material, that seems to infringe the derivative works right on its face, okay, according to the statutory text, even though it might very well violate the idea-expression dichotomy, which is to say that the ideas and facts can't be protected. That is not a particularly odd reading of this particular language. Now, courts have helped with that. Courts have, by and large, said that you do have to incorporate copyrighted expression into the new work, that it's not enough just to be based upon. But the language itself is pretty broad. Okay, perhaps the most troubling part of the derivative works definition is the language that includes within the derivative works right the right to recast, modify, or recast, transform, or adapt the copyrighted work in any way. That is also very broad language, and again, that transform language would tend to alter, the fair use doctrine, and that's problematic because when you think about, when you look at the statute and its legislative history, Congress said that it was codifying the fair use doctrine as it has existed in the common law over time. It said that it had no intent to change the scope of fair use in any way. But at the same time, now we have this derivative works right, which would seem to say that the right to transform a pre-existing work is going to be, it does belong to the copyright holder, and so that's problematic. It also seems to give protection to the copyright holder over completely unforeseeable uses that the copyright holder would not have imagined, uses that, that the copyright holder is in a very poor position to exploit, things like satires involving their own works and other things like that. Okay, I'm running out of time here, so I'll just say a third similarity has to do with fair use. In the dogfighting statute, there was an exception for uses that involve serious religious, political, scientific, educational, journalistic value, those kinds of things. Fair use is very, very similar to that. Fair use says that the fair use of a copyrighted work, including the reproduction and copies for purposes such as criticism, comment, news reporting, teaching, okay, all of those things are actually, those categories are very similar to a lot of the categories that are in the dogfighting case. And at oral argument, Justice Breyer and some others said that these terms are extremely vague, that they're not really defined, we don't know what falls into those. But in fact, the vagueness in the fair use doctrine is much worse than the vagueness that's in the dogfighting exception, because in fair use, we have a couple of other things going on. Okay, first of all, courts routinely find no fair use even when a use does fall within one of those illustrative categories. And that's not true in the dogfighting case, okay? If it falls within one of those categories, they don't prosecute. But in our case, we often do find no fair use even where it does fall within one of the categories. Fair use is also very unpredictable in application. If you look at the last three Supreme Court cases, Harper and Rose, Sony, and Two Live Crew, each court, the district court, appellate court, and Supreme Court, reached a different decision at every level of all of those cases. And so this whole conference is evidence of the fact that we don't know what's going on between derivative works and fair use. And if we don't know, then how is your average person supposed to know what's prohibited, what's allowed? Okay, so I'll just go on from there and say that I think it's very unlikely that a court would actually find the derivative works right or fair use unconstitutionally overbroad or vague for a number of reasons. Number one, it involves civil liability, not criminal liability, and that's a difference that matters to the court. Also, and there are also a couple of other reasons which I can go into if you want, but in the sake of time, another thing is that overbreadth and vagueness, striking down a legislation on the grounds of overbreadth or vagueness, the court says is very strong medicine. It's not likely to do that if there are any limiting interpretations that can save the statute. And so I want to offer here what I consider to be modest proposals for interpreting the statutory language in a way that would save it from these overbreadth or vagueness concerns. And I say that they're modest mostly because I think that most of these can be done without doing much serious damage to the statutory language as it currently exists. So one is to keep on requiring that copyrighted expression appear actually in the derivative work, not just that the new work is based on. I think that's fairly well established, but we need to make sure that we do that. Also, we need, I think that we ought to interpret that language modified, transformed, or adapted in light of the specific examples that come before it, condensation, abridgment, translation, that kind of thing, which means that we'll end up applying those terms to essentially new forms of what is basically the copyright holder's own expression, just put into new media, new forms. Now, that's still going to have some interpretive problems, but not nearly as much as what we have right now, which applies to just all kinds of new works. This is known as the canon of Noscatura Socius, and that means that you interpret some general language in light of other language that you see there to kind of nail it down. And this is frequently used to avoid overbreadth and vagueness in these kinds of First Amendment cases. In fact, Justice Scalia mentioned this as a way to deal with overbreadth in the dog fighting case and was discussing it with the advocates. Finally, I think that we need to look seriously at the issue of harm. We spent a lot of time talking about that in the last panel, so I won't go into it too much here, but I do think that we need to think pretty seriously about looking at not just negative effects of a derivative work on the original work, but also positive effects. The Fair Use Statute, as I said before, has the language effect, not harm, and so I think that we need to take all of that into account to decide whether these kinds of derivative works are the kinds that we want to prohibit, or whether we want to find that they're fair. Okay, so I think that those are the main proposals, and I would welcome any additional suggestions on how to solve the problem. Thank you.
So good morning. First and foremost, I would like to say thank you to the Vanderbilt Journal of Entertainment and Technology Law and to Spencer for inviting me here. I'm delighted to be here to talk about my work on an idea that I feel hasn't been given enough consideration in copyright jurisprudence, which is the idea of authorship and property rights in literary and artistic works. Today, I'm going to confine my remarks to how authorship has changed in the digital age and what this means for copyright law as an institution to promote learning. If we think about authorship in the digital age, there are some characteristics that I hope to highlight first before I go into the legal issues. Web 2.0 first facilitates online collaboration, information sharing, and interoperability of standards in a way that encourages authorship that did not exist before. There is communal collaboration and collective ownership of creative works, and this is increasing online. So there are wikis, blogs, community radio, television, podcasts that distribute content over the internet. And the third point is that the connectivity of the internet allows for vast distribution of content to society once produced. And the question that I've been asking that is relevant to this morning's discussion is there any use with the internet and the development that has occurred when it comes to authorship, is whether there is any purpose in using the word property when it comes to literary and artistic works, right? Do we still need to think of creative works as property? And that's what I hope to talk about in this presentation. Okay, so in the analog world, when I say analog world, I mean the pre-digital environment where the reproduction of works created imperfect copies. So there was no reason for users to reproduce and redistribute works because copies were imperfect. The role of the author was distinct and separate from the role of the publisher, and that was also distinct and separate from the user. So the author as creator was separate from the publisher who would publish and distribute content, and the user was really just a consumer of works. They were just passive recipients of creative works. They did not assume the role of the author. They did not assume the role of the publisher. Now, the author, publisher, and user model had assumed that there would be an efficient market that would allow works to be transferred to the user. And the assumption is that an efficient market would be the best reward for authorship. That if we were to move away from the traditional mode of remunerating authors, which was the patronage system, we need an efficient market that would allow rights to transfer from author to the user. And because of that, there were several things that needed to be in place. One, we needed a system that would grant exclusive rights to allow the author to recover the cost of producing and distributing the work. Second, we would also need a right to exclude, an exclusive right that would provide a baseline right that would allow negotiations to occur. And the third thing that we needed was that we needed an efficient market, because that's how learning would occur. If creative works were transferred to the user via the market, that's how that's how society will have works for the purposes of learning. So if you look at the ecology of the digital world today, it seems to have changed, and the focus has shifted from the author to the user. So the user of creative works is not only the creator of the work, they are also the publisher and the distributor. So the user is no longer a passive recipient, but an active reproducer of goods. And so with the internet, authorship is not necessarily commercially driven. The baseline right to exclude is not necessary to transfer rights. Rights many times are voluntarily waived. If you look at Creative Commons, some of the free software movement projects, these are all projects that allows rights to be voluntarily waived. And the third thing is that economic efficiency is no longer a normative criterion for protecting works of authorship. And so the question is, do we really need property rights in literary and artistic works? Then become questionable. My idea is that as conventional notions of authorship change in the digital age, there is a need to change our understanding of property rights as they pertain to literary and artistic works. So the idea that property rights are needed to encourage authorship may not necessarily be true in the digital age. If you look at authorship in the analog world, it is predominantly individualistic. Or if it's not, you would be able to identify the co-author or the co-creator. Authors always borrow from others, so I'm not advocating the romantic author. That's not what I'm saying. But when authors do borrow, we still know who the author is, right? So if Shakespeare borrowed from Christopher Marlowe, we still know who the original author is. If Milton borrowed from the Bible, we still know who authored Paradise Lost. So we always know who the author is, even though they do borrow from others. So I'm not advocating the sole romantic author. Works of authorship is always the personal expression of the author. The dissemination of works is usually through a publisher, and the cost of production and dissemination is very high. In the digital world, authorship is usually communal, so it's seldom individual. Authors are very willing to share with others. So think about MIT's open courseware project. There is an openness and a willingness to share. It's often collaborative. Dissemination by the author or creator is common, and the cost of production and dissemination is low. And so how does the law encourage authorship to occur? And the law does this by granting exclusive rights, right? And this, I think everyone here knows about this 5 or 6 rights that the law grants to encourage authorship to occur. Now, in the analog world, these rights encourage authorship for society's benefit, right? So these rights are granted as a temporary monopoly to ultimately benefit society. But the way it's done is that if the law grants these rights, then authors will produce, and ultimately society will benefit from the production of these works. So it serves a fundamentally utilitarian purpose. But in the digital world, authorship self-perpetuates. It occurs without this incentive, because people want to share through collaborative and communal effort. The reward for authorship is not economic but personal, right? Oftentimes, to build reputation, obtain satisfaction through contribution, or for altruistic reasons. Some argue that property rights restrict creativity and innovative activity by removing from the public domain what belongs to society, right? Therefore, the increased propertization of creative works, many people argue, stifles creativity. But my thinking is that it doesn't mean that just because technology allows society to collaborate, we no longer have a need for a property system. And my thesis is that as authorship in a digital age is collaborative and communal, there is a greater need for a strong property regime. So let me give you my reasons. Yeah, and so my idea is that we need a strong property regime, not for the reasons that we have traditionally protected property rights in creative works, but so it's no longer about production and distribution, but it's about sustainability. We have to sustain the production of creative works, right? So how does property rights shift? And this is what I am suggesting. That property rights in the digital age serves to identify the original author. And we need to know who the original author is as the creator and the owner of the work, because property rights define ownership, right? We need to encourage society who wants to use work to clear rights from the person who owns works. And the only way we can do that is if we have a clear and robust system for identifying the creator of the work. We need to sustain creative productivity. And by that, we need to recognize those who create and contribute to this pool of creative works on the internet. And we also need to recognize individuality. And this is not a new idea. Property scholars have argued that if a thing is so closely connected to one's personality, we should protect that thing as property. And the scholars who most notably make this argument are like scholars such as Margaret Radin, William Hegel, who she builds upon, right? So this is not a new idea. And so my idea is that abridging rights is something that we have to be cautious about. So if we do abridge rights, we will carve out society's interest and set boundaries around the public domain. But what we will also do is deny the importance of copyright law as an institution to serve a production and distribution function, right? And ultimately, my thought is that this will undermine the process of authorship. And so, I do have some thoughts that if we do want to abridge property rights, we should only do this if we can show that if we were to abridge rights, none of the ideals intended when the rights were first granted will be at stake. That means if we do abridge rights, we are not going to affect how authors create, right? So that's the first thing. Number two, a competing right will be undermined otherwise. That means if we do not abridge rights, then there will be another right out there, such as and the example I gave here is that of an author's ability to control public users of their work will be undermined. And the third reason why, or the third condition where rights can be abridged is that there will be an unanticipated social cost that goes beyond the cost anticipated when the rights were first granted. So this is my thoughts, and if you have any comments on my work, I'd be happy to hear them. Thank you.
So let me also add my thanks to the Journal's Symposium organizers and to Vanderbilt Law School for organizing what's already been a really enjoyable and useful day to my thinking about copyright. My topic today is a preliminary First Amendment analysis of the constitutionality of legislation that would treat news aggregation as copyright infringement. And my interest in this is born right out of, not surprisingly, the news. But particularly, the widespread stories about the declining profitability of the news industry and the suggestion that many commentators are making, or some commentators are making, that if we don't do something, then soon there will be no correspondents in Afghanistan or Moscow or any of the other places that news organizations presently send people, because news just isn't going to be profitable enough to be economically sustained. And one of the ways that we might deal with this is through legislation. Now, I've chosen to look at the question of constitutionality as opposed to, is it desirable, which it might or might not be, or could it be remedied through existing copyright law, which it might or might not be, because I think for two reasons. One is, some people are saying that legislation does need to be passed. And second, I think that a discussion about the constitutionality of legislation also tells us something about the constitutionality of judicial solutions or any other kinds of solutions that are not legislative in nature that we might craft as responses to the problem of the news industry's declining profitability. So to place the kind of legislation that I'm talking about, sort of squarely before us, let me talk about what I think is, quote, the problem. And again, there may be other views as to what the problem is. But I think the newspaper industry believes the problem is that their content is being used by others to generate advertising revenue that the newspaper industry used to monopolize or get the lion's share of. Right? I don't think the newspaper industry has ever been profitable because they made money by having you put a dime in a box somewhere and then get the Globe or the Times or whatever it is. I mean, they did make money that way, but that wasn't how they really made their money. They made money because your relationship with the newspaper every morning over your coffee or sitting on the bus or the subway was a set of eyeballs, and they could sell a lot of advertisements because your eyes would pass over the newspaper every day and scanning for what you were interested in. That doesn't happen anymore. Nowadays, my dad's a perfect example. He canceled his subscription to the Los Angeles Times. He canceled his subscription to the New York Times. He's canceled his subscription to the print version of the Wall Street Journal because he reads the news online. And what do I mean when they read the news online? What I mean is I think that people tend to go now to the news aggregator, which is someone who, as a general rule, posts the headline of a news story and then maybe makes it possible to read the first sentence or maybe two sentences of the story itself. And then if you're interested in reading more about, Obama, elected as president or Red Sox lose to Yankees yet again, you click on that and then you're taken to the Boston Globe site or to the New York Times website and so on. The problem here is, though, now, that for the value of scanning, right, to the extent that the newspaper business is making money because you scan the newspaper, they're not getting that revenue anymore. Now what's happening is, as you scan any of the news aggregators that you might choose to patronize, whether it's Google News or whatever, you're not paying the newspaper. You're paying, rather, the advertisers aren't paying the newspapers, the advertisers are paying the aggregator. And so they want that money back. And so the possibilities are to treat either the linking itself, right, linking to the news stories as a form of copyright infringement, or to call either the use of the headline or the link or the lead sentence, or possibly both, as a form of copyright infringement. So that's the kind of proposal. If we had legislation that said we're going to call that copyright infringement so that newspapers could go to Google or whatnot and say, they have, but we'll leave that aside, and say, look, no question about it, we win our copyright lawsuit because we have special legislation saying that we can prohibit you from this practice. So in order to analyze this, let me start with some copyright basics, which are going to become important as we talk about the constitutionality of legislation trying to prohibit aggregation. So copyright protects, as you all know, original works of authorship. The standard for originality is very low. It requires a minimal level of creativity, and so we're going to find that this becomes important when one talks about the potential copyrightability of headlines, which are minimally creative short snippets of work. Also, it's important to understand that copyright does not prohibit all uses of copyright works. Copyright does not even prohibit all borrowing from copyrighted works. Copyright grants the copyright owner 6 specific rights: the right to make copies, the right to make derivative works, public performance, public display, and digital audio transmission for sound recordings. So not every use that one might make of copyrighted works is infringement. Also, we learned that copyright does not extend to facts out of Section 102B. Well, that's because facts aren't original. Nobody creates facts. At least that's what the Supreme Court says. Of course, there are created facts out there, as anyone who's taken a copyright class knows. Copyright does not protect ideas. So that means only the expression in, let's say, text of a given idea is infringement. The underlying ideas themselves remain free for everyone to use. Courts are so serious about that that in cases where an underlying idea is capable of expression in only a relatively limited number of ways, the expressions themselves are also denied protection in copyright, because otherwise protection in copyright itself would be tantamount to copyrighting the underlying ideas. And then finally, of course, we have the fair use doctrine, of which a fair amount has already been said today, which encompasses 4 factors: the purpose for the borrowing, the amount borrowed, the nature of the copyrighted work, and the effect on the marketplace for the copyrighted work. So when we take this pattern of copyright law, do news aggregators commit infringement, right? Is there any potential need for such legislation, or can they just frankly get it out of copyright law? And my tentative conclusion is that in most cases, or at least lots and lots of cases, aggregators do not commit infringement. In some cases they might, but in lots of cases they do not. Now why? Well, first, I think it's fairly clear, and I think Professor Cotter had such a slide up, that hyperlinking is not considered infringement. No, he linked to a case that involved hyperlinking, but he didn't say this, so I will have to say it. Hyperlinking itself does not involve a copyright violation. Why? Because hyperlinking is not a copy. You don't make a copy of a work, and courts have in fact so held. So I don't think that, to the extent that a newspaper wanted to sue a news aggregator simply for linking to a story, that would constitute a very good cause of action for copyright infringement. As I suggested earlier, I think most headlines are not copyrightable for lack of originality. You know, Obama beats Bush. You know, how creative is that? Oh, sure, you know, socks slyly slip into 7th place. Oh, all right. Maybe some hypothetical headlines are copyrightable, the clever, the sly, but there are lots and lots of headlines, perhaps the headlines most susceptible of being borrowed by news aggregators, that are not copyrightable and therefore not the good subject of a copyright suit. Even if a court were to find a headline sufficiently original, I suspect that the merger of idea and expression dichotomy doctrine, the merger of idea and expression would defeat such an action, because in the limited space that headlines have to occupy, there are relatively few ways to express the underlying fact or idea that is the subject matter of the story. So again, I think there's a very good reason to deny copyright to headlines. Again, I could imagine a case where that were not so, but that'll be my position for now. I think the same thing would probably be the case with respect to lead sentences. Sure, some lead sentences are going to be copyrightable. Others will likely not be copyrightable because they are the bald statement of particular facts. You know, on Tuesday afternoon, President Obama went to the United Nations to address the General Assembly. Yeah, we can have an argument about that, but I really don't think that's copyrightable. And then finally, I think that fair use would still shield a number of uses of what would otherwise be potentially copyright infringement from a final finding of infringement. First of all, the purpose of the borrowing, as Professor Cotter had suggested in his presentation, has now been changed. It's not to read the work, it is to present the work for purposes of deciding whether you want to investigate further. The amount taken would be very small. The nature of the work is a factual work, the type of work that is most susceptible of fair use. And then substitution, at least in a number of fair use cases would probably be analyzed on the lines of nobody reads just the headline and one sentence as a substitute for an entire news article. That's not the way the audience would conceive of the borrowing. Now, I do admit, and again, this is to be fully candid, I think that there is an argument to be made that the real market for news articles is not to readers. The real market for news articles is to advertisers, and that articles are effectively sold to advertisers as the attractant on which to put advertisement. And if one's thought it that way, then perhaps, at least in some cases, the activity of news aggregators might be called copyright infringement. So I want to try to be as even-handed as possible. But again, I think my overall point remains, which is large numbers, if not a majority of instances of news aggregation do not commit infringement, at least news aggregation as I have defined it. There's other forms of news aggregation that I've left out. Not considered infringement, and therefore, perhaps there is a need, if you wanted to internalize back to newspapers the benefits of news aggregation, some need for copyright legislation. So how would such legislation to prohibit linking or aggregation generally, the use of headlines and lead sentences, be viewed under the Copyright Act? It is, in a sense, right, giving out more copyright rights than presently exist. One possibility would be to look at these cases under Eldred versus Ashcroft, a case that Professor Bohannon mentioned, which was an extension of the term of copyright, right, a handing out of more copyright rights. And the Supreme Court there applied an extremely deferential standard of review when that statute was challenged under the First Amendment. However, I don't think that a deferential standard of review would be applied to news aggregation cases, or at least I think it ought not to be. Because in the Eldred case, the Supreme Court explained that copyright does not normally present First Amendment problems because it increases the marketplace for ideas by encouraging people to speak. To the extent that copyright prohibits people from speaking, traditional doctrines such as the idea-expression dichotomy and fair use allow people to borrow from copyrighted works in ways that do not unduly burden other speakers. And so the Supreme Court said that there's deferential review as long as Congress does not change the traditional contours of copyright, referring specifically to the fair use doctrine and the idea-expression dichotomy. I would argue that legislation of the sort I have suggested here with respect to news aggregation would change the traditional contours of copyright. It would protect the kinds of subject matter, either unprotected as not original, unprotected as the merged expression of idea, or unprotected as fair use. And so the Supreme Court could not simply say, well, whatever Congress wants to do, that's fine, as long as it's hold your nose rational, we'll accept it. Now there has to be an elevated level of scrutiny. And I think that elevated level of scrutiny that would be applied by courts would likely be some kind of intermediate level scrutiny of the sort suggested in the Golan case. And in fact, the case that was cited there as precedent for the appropriate level of scrutiny, Turner versus FCC, provides a very interesting template on which to analyze the potential constitutionality of legislation trying to limit aggregation. In Turner versus FCC, government passed a regulation that required cable TV operators to carry over-the-air cable TV signals. The reason that the government instituted must carry was the government's concern that with the advent of cable television, regular over-the-air broadcasters would suffer economically, lose their economic profitability, and finally go under. And that was something that the government did not want to happen because they wanted to keep that kind of broadcasting available and keep it profitable. Now, in Turner, the cable operators sued, alleging that this was a violation of their First Amendment. You can see why, right? We don't want to carry other people's speech. That's a violation of our right to choose what we say. In Turner, the court said the government purpose in passing must carry was a constitutionally acceptable motivation for regulating speech. There were three related important governmental interests: preserving the benefits of free over-the-air local broadcast television, promoting widespread dissemination of information from a multiplicity of sources, and 3, promoting fair competition in the television programming market. And then, where government acts for that proper purpose, the court then inquires as to whether the regulation burdens substantially more speech than is necessary to advance the purpose. And in this case, the Supreme Court said that must carry was not sweeping too broadly. Why? Well, first, and perhaps most important, it didn't prohibit any of the news stations from carrying the kind of speech that they would ordinarily carry. They got to do there's so many cable channels that it only affected a few. And second, this regulation, in fact, increased the access of the public to information. Now, we could imagine the same kind of pro-regulation argument being made on behalf of those trying to regulate news aggregation. Like over-the-air broadcasting, the traditional news industry is in trouble. So why not force those benefiting, or those who are going to do better than the traditional news industry, to do something to prop up the news industry? But I think that there's 2 very big distinctions here that suggest that there would be constitutional problems with the kind of legislation I've suggested with news aggregation. First, and perhaps most importantly, as we noted in the FCC Turner case, none of the cable TV operators was prohibited from speaking as they previously would have. Everything they were going to say before, they still get to say. That's not true in news aggregation. Now there's a certain type of communicative activity in which news aggregators used to be allowed to do, but they can't do anymore. Second, to the extent that the Supreme Court found the regulation in Turner acceptable because it increased public access to news, or to television programming generally, that's not the case with legislation trying to restrict news aggregation. Here, the public will get less news than it would otherwise have gotten. And so I suggest, because of that, it would not be obvious to me that Turner would shield legislation against news aggregation. So let me just say, in closing, that this kind of quick analysis tells us that Congress probably does not have carte blanche to do whatever it likes in an effort to rescue the traditional news industry. And again, I'm not saying that it would be desirable, but if they chose to do so, I don't think they have carte blanche. Would there be something else they could do other than the straight prohibition of news aggregation that might be of interest? And I'll just throw this out here as an idea for us to discuss. Perhaps we could have some kind of micropayment, to use economics jargon, liability rule only, no injunctive relief. It's a compulsory license that would allow those who are news aggregators to pay to news operators, news organizations who register, very small fees as a result of their news aggregation. Such a thing would not prohibit news aggregators from doing what they do, thus making it more acceptable under a Turner analysis. And if the financial amount of the burden were kept small enough, that might not be considered inappropriate. So again, there's no detail on this, just an idea for us to consider as maybe something that would be more acceptable than the outright prohibition of news aggregation. Thank you.
Okay, questions? Yeah, Tom.
I have one question for Professor Henning and one for Professor Young. Professor Henning, I'm wondering if ultimately arguing for some sort of revised version of moral rights, specifically a moral right of attribution, or in addition, some change to the exclusive, to the economic rights. In other words, Professor Young, what about as another alternative? I'm not saying this is necessarily desirable, but I wonder, what if Congress created by statute some version of the hot news doctrine, so it would be time sensitive in its duration? Would they have the power to do that, I wonder, pursuant to the Commerce Clause, or analogous debate about database legislation? And would there be any First Amendment issues surrounding that sort of statute?
I think that's a really good question, and I've been looking at the moral rights issue in my work, but I haven't gone as far as calling them moral rights. So right now, I'm still calling them property rights, but they are I seem to be going in the direction of saying that because they are property rights, they should allow the author to exclude users that he doesn't that he feels goes against his integrity. Right? That's the only reason why he would want to exclude society from using his work, and that's precisely a moral right argument. And I might go in that direction, but I haven't gone as far as calling them moral rights. But But I do think that there is a distinction between property rights and economic incentives that we haven't articulated in our jurisprudence. And I think we have to start looking at property rights as separate from the 106 rights that are really economic incentives and a right to use as opposed to a right in a thing. And that's where I'm going with my work.
My initial reaction is that the hot news doctrine, all right, without having thought it through, I guess I'm thinking like you do, that some version of the hot news doctrine would be constitutional if it were kept extremely short, the way I think the hot news doctrine is meant. I also think that the hot news doctrine wouldn't do doodly squat for the newspaper business, because by the time I get to Google News, the hot news aspect of what happened yesterday night in Afghanistan is long past. So I think they need more if they're going to get something valuable.
Yeah.
I have questions also for Professor Singh and Ian. I liked your chart that showed the differences in the types of works, but I think that it was not as thorough for digital works because there are also digital works that have the same attributes as analog works. And I'm now thinking about works that are commercially created by publishers. They don't have sequential authorship necessarily in some of that. So I think if you're exploring this more, you might want to think about that there are some that are very akin to traditional works in addition to the others. Just a comment. And Fred, I wanted to ask you how you would differentiate between what libraries have traditionally done, like taking headlines and using them to create finding tools, as opposed to aggregating them. Do you think there's any difference with that?
Well, I think I was opining before that I thought that what newspapers did was fair use, and I suspect that what libraries do is fair use in a large number of situations. I think that, I don't know that copyright doctrine necessarily makes this distinction, but libraries, of course, do this, and they don't impact the advertising revenue of newspapers at all. And so that to the extent that one were concerned about this, little activity of libraries would not be a good target for the newspaper industry to go after, whereas news aggregators are. I think another thing that your comment raises, which I think is something that I haven't raised here at all, which is, of course, there would be this real problem of if you were to pass news aggregation legislation, how would you limit it so that it was really directed toward the segments of the economy that were really at stake? I fully admit that that would be a problem. And again, I'm looking at the questions of constitutionality, not whether do I think the legislation is a good idea.
Right.
I'm actually, it's kind of dodgy about whether I think it's actually a good idea.
Could I have just one follow-up, and
Sure.
maybe Danielle, if he's still in here, needs to be the answer to that, but if headlines are protected in Europe, then even a library that uses headlines and then directs you to the newspaper's website is reusing the headlines, and I wonder.
Yeah, I mean, I can't opine about the state of the law in Europe. I mean, I don't consider myself competent to do that.
Sure you can.
I'm a law professor. I'll opine about anything, right? How about nuclear? How about cold fusion?
Mike?
Also, a follow-up question for Fred. I realized at the outset of your outline and of your talk, you disclaimed an interest on the merits of whether it's a good idea to engage in this kind of legislation. But I do think that you need to wander a little bit into whether there's a causal connection between the aggregation by news and so forth and the economic problems that the print media have suffered. That clearly ad revenue is what's at stake, but there's a pretty interesting case to be made that what newspapers are seeing is reuse of their content in a way that actually has not affected their underlying business model to the extent that the damage has really been done by dramatic decline in classified advertising suggestion that the real remedy here is for Congress to allow newspapers to sponsor gambling as a way to, you legalize gambling through mainstream media, then you actually generate an enormous pool of revenue that would allow them to subsidize all kinds of traditional reporting.
Okay. Boy, there's a lot in that question, and I don't know if I'm going to try to. I'll successfully get everything in one fell swoop. On the general question of why are newspapers suffering, I think that you're right that we don't really know whether it's because there's declining classified ad, or I mean, obviously at some level their business model is broken, and it may or may not all be due entirely to copyright infringement. I think it's fair to say, though, that the newspaper industry is declining and that is a problem of social, I mean, if the news industry declines, at least I'm willing to buy that that's a problem of social importance. And regardless of the reasons why, and regardless of whether that's a dead business model, that's something that government might want to do something about. Okay, because I happen to think that it's a good thing that we have organizations that hold themselves out as purveyors of honest information. I also think, though, that when I look at it, I'm not entirely sure that this kind of legislation is necessary, in part because when I look at the activities of aggregators, there are a lot of aggregators that commit just flat-out copyright infringement. I mean, there's just no ifs, ands, or buts. They take the entire image from the New York Times website, the picture of whatever, and use it. That's flat-out copyright infringement. You don't need special legislation. They've just got to decide to get off their keisters and sue. The final thing that I would say is I forgot what I was going to say. Never mind. If I think of it, I'll come up with it. I told you I wouldn't get it in one fell swoop.
So I'm going to take moderator's privilege. I'm going to follow up on that once quickly, and then I want to ask a question to Christina. So the follow-up is, on this question of causation, if you could say with any confidence that the real issue here was that you're losing the eyeballs so that you're losing, the kinds of ad revenue you might get. The flip side of that story is by allowing your articles to be captured in the news aggregators. I wind up reading articles in newspapers that I never would ordinarily encounter. So there's actually driving additional traffic to the ads that are placed on the particular page. One might think that a sort of natural way to do this is to sort of do it similar to the way we do with other things on the internet is, can there be some kind of technological fix here that you get a robots.txt file, and if it's there, then you can't aggregate it, and if it's not there, then you can aggregate it, and I suspect most newspapers would want their stuff aggregated, right? Which I think goes to Mike's point that if that's true and they want it aggregated, then this isn't really what's going on here, right? This is just we're sort of using this as a substitute way to generate revenue that's being lost in other.
All right, so your question jogged my memory of what I was going to say to Professor Madison.
Perfect.
So let me try to answer them both. First of all, with respect to robots.txt files, I think that there are some news aggregators, including Google News and such, that respect them, so that people who don't want to be aggregated aren't being aggregated by Google News. I think you're absolutely right. Newspapers want to have it both ways. They want to be both aggregated and paid to be aggregated. All right, I think it's a policy question whether we want to allow them to have both, right? That's a policy question.
But you could have a much narrower regulation that just said to aggregators, you have to respect a TXT file.
You could do that, conceivably, yes. I'm a little concerned about that, perhaps, in the sense that you might wind up prohibiting people from doing stuff that was not aggregation.
Yeah.
Let me say, that in response to what Professor Madison raised, what I wanted to say was that I think that you can see at least some news organizations successfully monetizing aggregation. For example, AP gets payments from Google. I don't think it's just for the privilege of aggregation. I think there's really more of almost a joint venture going on here, where AP not only agrees not to sue Google in return for a fee for Google's aggregation, but does things to make life easier for Google, right? Gives Google access to AP photographs, for example, and maybe in return Google will bump AP search results up on its search engine so that it would both drive traffic to the newspaper more effectively, like you say, but also provide benefits to the aggregator, such as access to copyrighted content that might, quote, fix the problem effectively. At least that's a possibility.
Okay, so now my quick question for Christina. So, Christina, the question about how you would deal with the derivative work right, I think depends a lot on how we understand what the traditional contours of copyright are. Right? And I think the question is, after Eldred, do we read that case as having defined for us the full scope of what the traditional contours are by reference to fair use, idea expression, those kind of things? And if not, what other things count as traditional contours and at what time frame, right? Because traditional could mean, as originally, existed at the time of the First Amendment. It could mean we've had it for a long time. We've had something like the derivative right for some time now. Does that count as a traditional contour? How do we fill that in?
It's a really good question, and it's really hard. You're right. How we view traditional contours is going to depend in large part on what period of time we're talking about. If you look at the very first Copyright Act, maps, charts, books, no derivative works. But then later we have judicial decisions and other things saying, yes, okay, translations are not protected, and Congress comes along and says, yes, they are, and so on. And so it is kind of hard to tell. I think, I guess I would say a couple of things. It is. I think it's anybody's guess what the Supreme Court had in mind when it said traditional contours. It did mention idea expression and fair use, but fair use is totally a moving target because of these other changes over time. And is there anything else beyond those two doctrines to the traditional contours? I'm really not sure. They gave so little on that. I mean, it was literally, 2 or 3 sentences on this traditional contours thing, and then they're gone. And now all First Amendment analysis turns on this traditional contour stuff. So I think that that's really hard. I think maybe they're wanting us to work on this for a while, and then maybe they'll come back to it. But I would say a couple of things. I think that this derivative works right is problematic because what it does do that I think is different from pretty much all of the derivative work stuff that we saw come before the right was added is that it doesn't just apply to, abridgments were already in the law. That's kind of the fair use doctrine. Translations, those kinds of things were all in the law. These are all, I think, can be viewed as, new forms of basically the same story that the copyright holder was telling. Now you have situations that would be covered by the derivative works right that are pretty unforeseeable and that are not just merely representations, but are actually totally new messages, new meaning, new communication, which I think is fundamentally a problem for First Amendment. And then quickly, I'll just say that's one of the reasons why I was focusing on vagueness and overbreadth, because those things don't necessarily turn on the Eldred Court's analysis about traditional contours.
But in order to get to those questions, you have to assume it's outside the bounds of traditional contours. So
to
that
some
First
degree
Amendment
you do, yes. I mean, definitely with overbreadth, not necessarily with vagueness, but yeah.
Right.
Just as a follow-up of your question for Christina, I'm very curious about how broadly you intend for your framework to apply, because to the extent that you're suggesting that, I think you're suggesting that certain aspects of the Copyright Act are unconstitutional for reasons of overbreadth and vagueness, it occurs to me that almost every argument that you make could be applied to right down the middle of copyright law. You don't need the derivative work right. Frankly, the substantial similarity doctrine's got the same problem. And if you're talking about substantial similarity and fair use together, it seems to me at that point there's no longer a constitutionally viable cause of action. And so I'm curious if you intend for your analysis to push that far, or if not, what the distinguishing features are in the middle there that would say that this is really just about the derivative work right and not about just the entire concept of copyright.
Yeah, that's another great question. I mean, and this idea here is about 2 weeks old, so I'll definitely have to give more thought to that. But I mean, you're right. I do think actually that substantial similarity is a problem. I think that's one of the reasons why, for example, Shams Balganesh's paper talks about needing a foreseeable copying element of substantial similarity. He didn't rest this on First Amendment per se, but I think the same issue is here, that just is very hard to know, and it doesn't seem like it's limited in any way to copyright incentives and that kind of thing. So I'll have to think about how much more I want to bring into this. I think that one of the reasons why I focused on derivative works is because when you look at First Amendment doctrine and other cases, other examples of statutes where, there's certain language that's been problematic for the court and have said, oh, there's overbreadth and there's vagueness, that the derivative works right sounds like some of those. This dogfighting statute is one of them, but I think I'm trying to follow up on what it is that the court's finding wrong in some of these other kinds of statutes. But I think that a lot of this is about the fair use doctrine and how that intersects with derivative works right. And so I think a lot of this is really a problem about fair use, and I think that does cut across copyright generally, and that it is extremely problematic these days. I mean, I think people are finding it extremely difficult to rely on fair use in any meaningful way and to have any notice of what is going on. Publishers and copy shops and other intermediaries, they just won't rely on it. That does seem to me to be a pretty fundamental problem when you're talking about these traditional contours and copyright and First Amendment. So I think a lot of it is fair use, and I think it is. I think it does cut across a lot of copyright. But I'll have to work on it some more to see.
So,
you know.
so if I could suggest a friendly amendment to your thesis here, rather than a frontal assault on the existence of these provisions, perhaps that you would get more out of looking at something like the law of libel than the law of overbreadth and vagueness, because in libel you had one particular line that was drawn between truth and falsity that was supposed to govern what was constitutionally suppressible and what was not, in a civil action, by the way, which would also
Right.
help you. And the Supreme Court, recognizing many of the problems that you recognize in libel law, said, well, in order to avoid First Amendment problems, judges are obligated to interpret the law of libel in certain ways, the public figure doctrine and so on. And I think that if you could say that these are the kinds of things that matter in the interpretation of copyright law. There are certain types of interpretations where the thumb on the scale has to be on the side of the defendant in order to avoid the chilling effect.
Mm-hmm. Yeah, and actually, I just quickly to follow up on that. I recently wrote a paper that relates to proof of harm, and First Amendment, and I did use libel law there in defamation to talk about that, because the thing I said is that typically, and this goes to the fair use point and some of the stuff that happened earlier that we were talking about with recognizing harm, is that generally we say that if you're dealing with speech, you can't condemn speech unless there's a harm that the speech is causing that the government has an interest in avoiding or preventing, and so I argued, using some of those rules from defamation and libel and those things, that you do have to prove harm of a certain kind in those cases, and that we need to take that more seriously in copyright law, and it does kind of put that thumb on the scale of saying free speech is free unless there's this serious countervailing interest. But I think this might be helpful to this project as well, looking for some bright line rules.
Someone had a hand over here. Yeah.
One question for Christina and Alina. So Christina, the trouble I have with First Amendment in IP is I never quite get how you draw the lines between what's infringing and not. I can understand the vagueness or overbreadth concern. That means the line has to be clear. But does that really tell us that, say, making a film from a novel has to be on one side of the line, whereas making a sort of mashup of some kind is on the other side of that line? When Tom and I were presenting our arguments, we were sort of using economic analysis and the toolbox that gives you to figure out where approximately the line should be drawn, given the uncertainty about some assumptions and
Right.
political issues we couldn't resolve, might draw it one place or the other. So in terms of the First Amendment, is it telling us where to draw the line, or that wherever we draw a line, it just needs to be clear?
Yeah, I mean, I think in this particular paper, I'm dealing more with the clarity issue. I think that the problem of notice is really problematic here. Not knowing whether your thing falls within fair use or not, I think, is a huge problem. And I think that it's just interesting to me to see a court arguing with these lawyers about the meaning of this dogfighting statute and how will you know whether it falls within this exception or whatever. And we just don't do that in copyright. We don't know whether something's fair use or not, but somehow the court doesn't seem that troubled with it. And I think it does relate to your first the first point, which is that we don't know how far the rights should go, how far the entitlement should go, and the court has deferred to Congress largely on that issue, maybe for some good reasons. But I do think that's. I recently, though, written a paper where I do argue that we need to take harm more seriously, because in all of the other areas of law, I'll just give you an example. Okay, so in libel, we don't say, well, you said something that was bad about this person. You could have said something that was good about this person. You failed to benefit them, But in copyright law, we're sort of saying, well, we don't know if we really harmed them, but this license fee could have helped them in some way. And I mean, the right in your reputation is sort of a property right, just like copyright's a property right of sorts. And it just seems that the way courts, and I couldn't deal with all this here. It's like a 65-page paper, but I mean, it's the point is that the way the amount of harm and the kind of harm that is usually required for, you know, for other types of legislation to pass muster under the First Amendment is different than what we look at in copyright. We tolerate a lot more speculation, a lot more kind of, you know, wishy-washy forms of harm there and than we do in the First Amendment. And I think that's kind of where I've gone with some of the First Amendment stuff.
Glenn, did you have one?
Oh,
Yeah. Alina, so in your paper, you talk about thinking of copyright as a property right, not from the incentive perspective. And from what I read, it seemed like you were suggesting that the property rights and copyright play an important coordination role, just as they do for property rights and real or tangible goods. So I own my car, and now does that mean that I can get the economic advantage of it, that I can coordinate the use of it? If my son wants to borrow it, or someone else, a friend wants to borrow it, or I need to drive here or there, I can coordinate all those uses. Is that the sort of property vision you see with copyright? You're shaking your head yes, which leads me to the second question, which is, if it is, why do we need that sort of coordination? I understand the private good where you have physical rivalry in the consumption of it, like a car. My son is taking it, I can't drive it too, it's at the theater or wherever he took it to, I may not see it for another week or two. And so that really prevents my use, but in copyright, we don't have that sort of physical rivalry. You know, why do we need someone at the center coordinating which uses or derivative works or mashups are made from a given work of authorship, just from a coordination perspective? It's not an incentive to create the work at the outset, it's not necessary for that. Why do we need somebody coordinating those different uses all? Why not let all of them occur?
I think that's a really good question. The reason for making that distinction between the use right and the right in the thing, right, wasn't premised on whether the work was rival or non-exclusive. I think because precisely because the work is non-rival and non-exclusive, do we need that kind of use regulation to set and the reason why I think we should have that use regulation is to make sure that use of creative works are rightfully attributed to the person who created it. So if we don't regulate the use of creative works, then the notion of authorship gets diluted. And if the notion of authorship gets diluted, then we won't be able to sustain creativity. Does that make sense? Yeah.
Or regulate attribution without controlling or regulating use. So if someone makes a film from your book,
Right.
you have to acknowledge that it's based upon your book.
Right.
You don't have to get permission from you to make the movie.
Right, and I think you weren't here when I was answering Professor Cotter's question. The regulation of use, in my perspective, should only come into play when there is a use that that affects the author's integrity, right? So if I'm the author and society has unrestricted use of my work, as what you suggested, there may be times when the use of the work may offend me as the author, right? And the only reason why you would want to have a property rights, and I've labeled it property rights for the time being, is that you want to make sure that the one who created the work continues to create, because if society is using his work for purposes for which he doesn't agree, then the whole point of encouraging authorship loses its meaning, right? Because the whole point about the copyright system is if we want to encourage learning, we have to encourage authorship in the first place, right? Unless we encourage the author to create, then we will not be able to sustain creative production. Does that make sense?
Well, it makes sense, but you would wonder why an author would have his his or her feelings hurt because someone made a movie or something from their book. Why should it affect their vision of
Right.
You just say as a farmer, your feelings are hurt about how they use your tomatoes, tough, bud, you know? You're a farmer. You
Right.
have to say what they do with your tomatoes once you sell them. Why don't we just say that to the author as well?
But I think there is less of a connection between tomatoes and and expression, right?
Right?
It depends on the right. But yeah.
There first and then the law protected it, or the law protected it and then it arose.
But I think the fact is that the fact that the internet allows remixes and is precisely the reason why we should think about. So traditionally, when we've shifted when the rights were granted to encourage authorship for society, that means it was based on a utilitarian framework, right? The main beneficiary of the copyright system was society, right? But with technology, it seems that the benefit to society, which was to learn, has expanded way beyond what the copyright system intended, right? And it seems to be affecting what the author may intend his work to be used to be useful, and I think that balance has shifted, right? It seems to have given more rights to society than the system may have intended originally. And that's how I see it.
I just wanted to ask a question. I could ask the same thing, I guess, to Professor Carter as well, about you, all talking about harm. You seem to be focusing a lot on harm and basically drawing it back to the current fair use four-factor test. It would mostly focus on the fourth factor, which I think at one point the Supreme Court said was the most important factor, and then it's all gone back into the four factors. And I was asking kind of on a practical level, right? The first three factors, if you have, say, a defendant who gets sued, like I don't know if you're familiar with the Premise Media versus Lennon, or Lennon versus Premise Media case. Basically, there took 15 seconds, a movie producer took 15 seconds of Imagine and put it in the movie. And the movie was all about how intelligent design should be taught more in schools. And so the movie took 15 seconds of Imagine and basically said, if you take John Lennon's songbook, you know, all the people together and no religion too, this is what would happen. And you had pictures of Joseph Stalin and all that kind of stuff. Basically, I mean, clearly transformative use of the song. Now, in those kind of situations, what's the benefit of a defendant who could make a motion to dismiss and be out of the case on the standard four-factor test? Is the focus on harm worth the cost to that defendant of presumably having to go through months of discovery on licensing and those kind of questions and when they've clearly done something that should be protected under the Copyright Act, whether you agree with intelligent design or not, you know, they've taken something and put their own spin on it, and that's clearly something that's supposed to be, that's one of the values that's protected under the Act. I just want to get your thoughts on that.
I don't think it was directed toward newspaper aggregation.
No, pardon me, Christina.
Oh, okay, I'm sorry. Okay. Well, I guess I'm not sure exactly what the question is here, but
The question is, okay, so you focus so much on the fourth factor, harm, and extent of harm. That's something that can really, you couldn't resolve that on a motion to dismiss. You'd have to do discovery about
okay, I see.
licensing and all that kind of thing. So if you submit to the court, say, a video of the movie, and the court or the judge can look at it and say, that's clearly transformative. That's, you know, I mean, that's the essence of what we're talking about here, protecting people's rights. Defendants should be out of it, especially if you've moved for an injunction, say, as to the movie, and the movie is being held back while this court proceeding goes on. Is the benefit of focusing on harm worth that cost?
Oh, okay. So I think you're asking, you know, is it better to focus on harm or is it better to focus on transformativeness as transformativeness? I mean, just in and of itself. Yeah, I mean, my view on harm generally is my work on harm has mainly said that I think we ought to take it more seriously. That I think that because of copyright's incentive purpose and because of First Amendment concerns, that when somebody engages in speech using copyrighted expression, that we ought to have a pretty clear showing of harm. And if you look across First Amendment cases, you'll see that there are lots of cases where some kind of potential harm is alleged. Something might have happened, something bad might have happened coming out of the flag burning. It's going to breach the peace. People are going to be fighting. There's some harm potential out there. And I think a lot of the arguments in copyright law are the same, right? That I might have entered this market. I could have entered this market. They might have paid me if we don't call it fair use. Maybe they would pay me. I just don't think those kinds of speculative arguments about harm are generally what we see in the First Amendment context. So my basic point is that we need to take it more seriously. We ought to require pretty clear evidence of harm to the incentive idea of copyright. That's not to say that there aren't going to be some cases where the clear social benefit of the transformation doesn't clearly outweigh that harm. I actually have said, I actually think that what happens is that, we engage in this balancing between the social benefit of the use and the harm without really knowing what the harm is. We sort of assume that there might be some kind of harm there, and and there's a circularity, so it kind of gets difficult. And so I don't think that we really know what harm we're weighing when we weigh the social benefit against that. I think that we ought to require, stricter proof of harm. The kind of harm that we really actually think is going to affect incentives to create copyrighted works. And then even if we have that harm, though, I think that you could do this kind of transformative things, because there are going to be some situations where the social benefit just clearly outweighs that harm. And I don't think that I'm certainly not arguing that we ignore that.
Go ahead, Tom, since you addressed
Yeah, I mean,
your-
actually, something that I actually have in a more recent version of the paper that I haven't distributed anybody yet. I think the fourth factor, in light of my analysis, really ought to be, does the use at issue threaten cognizable harm? So I think the cognizability actually factors into the fourth element. And in the hypothetical you raised, which is based on that case, it seems to me that pretty clearly it ought to be non-cognizable harm. The makers of the film are critiquing the lyrics of the song.
But Mrs. Lennon would still argue, or Mrs. Ono, or whatever, would still argue that I should have had the right to license the song. So that's my harm. And not setting apart from whether or not I can license the song to Premise Media, I should have, if Premise Media can take my song and put it in their movie without my say-so, then anyone can do it.
But I guess I would analogize it more to a book review. You're quoting the work for the purpose of critiquing it, and at least the way I see it, that should be fair use per se.
Is there another question?
Yeah, I think so.
Oh,
Dan,
go ahead
you
then.
do.
Go ahead.
Oh, we're on time. Good. I want to go back to, I was still at that conversation, I was thinking about something else, but I want to go back to a point that I think Fred made about Christina's paper, the substantial similarity issue. And wouldn't that be related to the derivative work in this following sense? There's a big overlap between reproduction and derivative works. Actually, I think it's Mark Lemley who said you could actually get rid of derivative works if you think about it, which is circular because it depends how you define reproduction. But arguably, if something is if work B is substantially similar to work A, then work B is based upon work A. If the author of work B had access to work A, and so the overbreadth issue then would be the same. And if we follow that train of thought, then the derivative work becomes something like dilution in trademark law, where you're not sure whether there's confusion, so you create dilution. It's a little bit the same, where you're trying to catch cases where there's no copying per se if you define it strictly because you transform the format or the language. But in fact, the based upon test, that right becomes very much parallel to the substantial similarity argument. So I don't know if that makes any sense, but it seems to me the two are related in some way.
Oh, no, I totally agree with that. I think that they really are related, and you're right that today we have this rule that you have to substantially incorporate the copyrighted work into your other work in order for it to be a derivative work. I think a lot of what
what I'm saying is that, and I will think more about the substantial similarity point and whether I ought to address that, because that's a good point. I've been thinking about derivative works in part because I think that it has had an expansive effect on our view of reproduction. I'm not sure I can prove that well enough, that you know, because a lot of people are saying, well, it's kind of superfluous, we could get rid of it. We could get rid of it now and have the same rule. I'm not sure that we could have gotten rid of it 50 years ago and had the same rule. I mean, I think that over time, this notion about derivative works, is, you know, we've been expanding, and so I think it has had an expansive effect. But I also think that the derivative works right has become something that I'm not sure it was really ever intended to be. You know, when I've taught this, and maybe I'm totally teaching my students wrongly about this, but when I've taught this, you know, my students ask me, well, why do we have a derivative works right if it's all in the reproduction right? And we talk about that. And I think the thing that I say is it's kind of, I mean, think of it as kind of an amendment to the reproduction right, right? It's kind of this clarification that just because you change the medium or format of something doesn't mean you haven't infringed, that you look at substantial similarity of the expression, not the form necessarily. And that's kind of what that takes out, you know, of the equation. And because in part of some of the broad language that's used in the derivative works right, I think it's come to mean something much bigger than that, and it does have this kind of expansive effect on the reproduction right, and that's what troubles me about the derivative works right particularly. But I do need to think more about the substantial similarity point. You know, I'm sort of hesitant to say that the entire Copyright Act is overbroad and, you know, whatever. So I'll have to think more about that. And maybe ultimately this really is more about fair use than it is about anything else, because that's another part of this too, is how much fair use conflicts with the derivative works right in the language and that sort of thing. So maybe I ought to.
Okay, well, in the interest of getting you to lunch, we're gonna have to stop there, so, yeah. So I think we'll thank the panel and then we'll go to lunch. Thanks.